Blood alcohol content level is a measurement of alcohol ethanol in your blood system at a given time.
A lot of people forget this when they've been stopped. They're nervous, they're stressed out, they're freaking out, but you have rights. Constitutional rights when you've been stopped by a police officer. First, you have Fourth Amendment rights, which are rights against search and seizure. You have the right to refuse to answer questions. Routine roadside questioning, you should just answer, be polite. You don't have to do the field sobriety test. That can offer evidence against you. And most importantly, you have the right to refuse that breath test. There are going to be license implications of that choice, but if you're looking to beat this case, you have the right to refuse the breath test, and you should. There are 3 tests: horizontal gaze nystagmus. The next test is the 9-step walk and turn. And the last test is the 1-leg stand, where you're going to be asked to stand on one leg on the side of the road and count 1001, 1002, and so on until you're told to put your foot down.
You do have the constitutional right to say no to any field sobriety testing, and that cannot be used against you in trial.
On a first offense OUI, or if you have one prior offense outside of 10 years from your most recent offense, OUIs are so common in the district courts, the legislature established a diversion program called the 24D program. Convictions with no probation, you'll lose your driver's license for a year. But if you agree to the 24D program, then you have a 45-day license suspension.
The police are going to take you to the police station and book you. That's where they're going to offer you a breath test, just get general background information, and typically they'll have a bail clerk come in and determine whether or not you're going to be released on a bail. With an OUI, 9 times out of 10, you're going to be released that same night.
Oh my God, of course you can. That's our favorite thing to do. Listen, I tell people, I'm like, we'll go to trial on anything. But I think some people think like, oh, you really don't want to? I'm like, the best part about my job is cross-examining officers. It's fun. So I think there's a lot of different avenues to beat an OUI in Massachusetts. And, OUI laws in Massachusetts are very defendant-friendly. They're there to protect citizens and constitutional rights. That's why you call Gilman Law, we look at your case, and if it's a triable case, let's take it to trial and try for the not guilty.
You can definitely plead guilty to an OUI in Massachusetts, but that may not be the smartest thing for you to do because, for example, if it's a first offense OUI, you don't need to plead guilty. We can work out an agreement with the Commonwealth for what we call a continuance without a finding. That's not a guilty plea and therefore not a criminal conviction.
You can certainly resolve your OUI case very quickly, but there are significant consequences. You will have a license suspension, your insurance will go up, you will have an OUI on your driving record for the rest of your life. You'll be placed on probation with a period of incarceration over your head should you violate the terms of your probation. Let us do our due diligence to put you on the offensive, to defend you, and properly advise you as to how you can move forward and get on with your lives.
So if you are arrested for an OUI, again, the very first thing you should do is give our office a call, and we'll be able to handle everything from there.